Hello, everyone. We'll get started. I'm Patrick Bush. I work with the Legal Counsel Division of the State Court Administrator's Office. We're offering this CLE around the state of Minnesota to focus on the top 10 things you need to know when you use the e-filing system. This presentation has been approved for 1 standard hour of CLE credit. The number is 248463. For those of you attending by ITV, if you have questions at any point during the session, please unmute your microphones, ask the questions. I like questions, so please type up. Don't have any questions, please mute your microphones. Otherwise, we'll hear everything that you're saying here in Wilmer. For those of you in the room with me, please go right ahead. If you have questions at any point, raise your hand, get my attention somehow, ask them, and I will answer. Off and you push. Thank you. So the presentation is the top 10 things you need to know when you use the e-filing system. We in State Court Administration, since we transitioned to mandatory e-filing, have talked with judges and court administrators around the state. What do you see? What do people need to know when they come into court with e-filing? What do they need to know about? What do they need to do differently? We have seen some common mistakes, some common pitfalls, and so we've boiled that down to the top 10 things you need to know when you use the e-filing system. And let's talk about why this should matter for any person, but especially for attorneys, but for any person, you can be sanctioned if you don't follow the rules. And the rules were amended several times in 2015 and 2016 to facilitate the transition to electronic filing. And also, aside from sanctions, there's a possibility you might lose your case. You might lose the right to appeal, and that has happened. And for anybody, for any attorney, there is a risk of significant violations of your client's privacy if you're not careful when you use the e-filing system. And I'll talk in detail about what that might mean. And then also for the attorneys, there are some potential ethical issues. The number 1 ethical rule is the ethical duty of competence. And if you look at your handout at the end, I've attached the rules that I'm citing to. And so if you're wondering what the legal basis is for what I'm saying, just look at the end of your handout. The number 1 ethics rule is the duty of competence. And what that means, if you look at the comment to the rule, it includes both the duty to stay on top of changes in the law, so changes to court rules, and also changes in technology. As technology develops, some of your obligations may change as an attorney. And also often it's administrative staff who handle e-filing. However, there is, of course, the ethical duty to supervise your staff. So as attorneys, to the extent that your administrative support staff are handling e-filing, there are some potential ethical issues for you. If I talk about sanctions, this is a case from 2016. It's a Minnesota Court of Appeals case, and you can see a $999 award of sanctions. Now, what happened was at the district court level, there was a discovery dispute. First, the one side served the other with some demands for discovery, interrogatories, and it was an e-filing county, and so these were e-served. The other attorney didn't respond in a timely manner, and so there was a motion to compel discovery and a motion for sanctions, and the attorney's response was, well, there's no affidavit of service, so you can't sanction me because I didn't respond because there's no affidavit of service. And then the response to that was, well, the e-filing rules, they say that if you e-serve, you don't need an affidavit of service. The e-service records are sufficient proof of service. And so if you look at these e-service records, you can see not only on this date, at this time, they were served on the attorney, but actually down to the minute, you can see when the attorney opened the documents that were served on him when he clicked on the link. So the district court judge agreed that there's not a basis for failure to respond and sanctions are appropriate, $999 in attorney's fees. This was appealed to the Minnesota Court of Appeals, and the attorney said this is draconian, and that word is in the pleadings, and this should never have happened, and there was never an affidavit of service. And the Court of Appeals said, well, the rule does say you do not need an affidavit of service, and so we uphold the award of sanctions. Then there was a petition for further review filed with the Minnesota Supreme Court. That was denied. There was then, if you look at the case file, a petition for a writ of certiorari with the United States Supreme Court, also denied. So just in this case, it boiled down to, I think, maybe some embarrassment for the attorney, but also really it boils down to time and money. However, the consequences can be more serious. It mentioned loss of appeal. This is another Court of Appeals case, also from 2016. What happened was at the district court level, the client's parental rights had been terminated. And under the applicable court rules, if your parental rights are terminated, you have 20 days to perfect your appeal. And part of perfecting your appeal is you have to serve the notice of appeal on the other side, on the county social services agency. And so in this case, the attorney's, well within the 20-day limit, the attorney's assistant, put together all the notice of appeal and emailed, not e-served, emailed everything to the county social services agency. And then as the county social services agency said, well, hold on, we did not agree to service by email. You needed to have e-service. And so there's no jurisdiction because we weren't timely served. And the Court of Appeals agreed. They held that they did not have jurisdiction to consider the appeal because it had been emailed. It had not been e-served within the 20-day deadline. And so, again, that was the client lost the right to appeal the termination of parental rights. And that was also, again, PFR denied by the Minnesota Supreme Court. Now, both of these situations, they could have been avoided had the attorneys read the rules. And so our number one thing you need to know is read the rules. A couple of specific rules where we see common issues, and these are rules that have been amended with e-filing. The first is General Rule of Practice 11. Show of hands, how many in the room can tell me what General Rule of Practice 11 says? I see a couple of hands. In law school, we talk about Rule 11 sanctions, and that means Civil Procedure Rule 11. In Minnesota State Court, there are two Rule 11s you can get sanctioned under. The other one is General Rule of Practice 11, and what that rule does is it deals with restricted identifiers, Social Security numbers, employer identification numbers, financial account numbers. And the rule has said for many years that the person who files the document is responsible for keeping those restricted identifiers out of public court documents because they can be used for identity theft. It's happened in other states. We don't want it to happen in Minnesota. And so the rule puts the burden on the filer to keep restricted identifiers out of public court documents. The change in 2015 was to introduce a striking process where if not only are you required to keep restricted identifiers out of public court documents, but if court staff find a restricted identifier in a public document, they can strike the filing. What that means is you lose your filing date, you have to re-prepare your document, and you have to, without the restricted identifier, file it again, pay the filing fee again, file it a second time, and there is a potential for additional sanctions by the judge. A number of judges have sanctioned attorneys for failure to keep out restricted identifiers. Another judge I know of gave the attorneys an option. Instead of sanctioning them, said, counsel, if you'd like, you may come in and I won't sanction you if you come in and redact the restricted identifiers, meaning both attorneys had to come in, and it was a stack of trial exhibits about 3 inches thick. They had to sit down with a permanent marker and black out. And they chose to do that instead of being sanctioned. And then the judge looked at it and saw that the marker, they'd started to run out of ink, and so it went from blacking it out to sort of graying it out. And so the judge sent them a letter saying, counsel, I know you have not fully, your marker ran out of ink, so you need to come back in. And they had to come back in a second time, and again, find time where they both could come into the courthouse. Two attorneys after a contentious divorce case probably didn't really want to see each other because they've been at each other's throats, and that is an example of what can happen. And again, the purpose is to prevent identity theft. State court records in several other states have been used to steal people's identities because they have social security numbers in them. The most recent one that I'm aware of was Alabama's state courts in 2017, where several people's identities were stolen. We do not want that to happen in Minnesota. So that is one of the things, that's why we have this rule. It's very strict, and it's one of the things that you need to keep in mind when you e-file. Speaking of e-filing, General Rule of Practice 14, that is the rule that governs e-filing and e-service in general. It does set out a set of requirements for e-filers. So when do you have to e-file? When do you have to e-serve? What are your responsibilities when you e-file and e-serve? And so if you want to know what your specific legal responsibilities are as an e-filer, you should look at Rule 14. And then there are the rules of public access to records of the judicial branch. Again, show of hands, who has read the rules of public access? I see several hands in the room. I am glad to see several hands up in the room here in Wilmer. The rules of public access, they govern all court records. They are under Minnesota law. That's what dictates which court documents are public, which aren't public. If you work in other state government agencies, you're probably under the Minnesota Government Data Practices Act. But if once you come into Minnesota state courts, what's public or not public is based on the rules of public access to records of the judicial branch. And again, still on the theme of reading the rules, non-compliance with the e-filing rules and with court rules in general can create ethical issues for attorneys. There's the duty to know the rules, to follow the rules, and to ensure that administrative staff, administrative professionals, paralegals, when they are involved with e-filing, that they are also acting in compliance with the rules. And pretty much everything you do on EFS is logged, it is audited, and EFS audit logs have been disclosed to the Office of Lawyers' Professional Responsibility. They have seen fit to investigate attorneys before for potential ethical violations over the use of EFS, of e-filing. So just in general, it is a very important thing to make sure that you are up to date on the rules as they've been amended in 2015, 2016. Number two thing you need to know, I talked about the rules of public access. Public can be everywhere. And what that means is with the transition to electronic filing, court records are a lot more easily accessible than they used to be. And if you look at the rules of public access, almost everything is public. The way they're written is all case records are public unless they're specifically listed in this rule, and then there's a long list of non-public case records. But the majority of case records are public, and you should assume the world will see everything you file with the court. Yes, that does include things like child protection cases. Those are public records. Dissolution cases, those are public records. Custody cases, public records. And yes, sometimes people do come in and want to read them. In general, confidentiality laws don't apply to court records. So HIPAA, for example, that applies to your insurance company, to your doctor, doesn't apply to court records. FERPA, Federal Educational Records Privacy Act, doesn't apply to court records. Minnesota Government Data Practices Act also does not apply to court records. There are a number of situations where something would be non-public under the Government Data Practices Act, but it's public once you file it in court. And you do need a legal basis to make things confidential. Judges do have the ability to order things as confidential, but they need to have a legal basis. Sometimes what we'll see is attorneys will just agree, this is sensitive information, we're going to file it in court. We'll both agree that the court can make it confidential. Thing is that is not legally a basis to make things confidential. I always like to talk about, as a lawyer, I gravitate towards what can go wrong. One example would be the late artist known as Prince, who went through a divorce case in Hennepin County District Court from 2006 to 2007. And understandably, given that one of the parties is a very famous international musician, they were concerned about privacy. And so both parties agreed to ask the court to they sent a proposed stipulated order to seal all of the records, and that was done early on when they filed for a divorce. And so the court signed that order in 2006, I think it was, and then from 2006 into 2007, the parties negotiated their dissolution, and they filed a number of sensitive personal details with the court, but they fully expecting that since there was this court order saying these records will and forever shall be non-public, that they were going to be non-public records. And that goes forward in 2007, divorce is done, and they both move on. 2016, Prince passes away, and then there's some public interest in his personal life, including his divorce file, and so the Star Tribune petitions for access to these court records. Understandably, the surviving ex-spouse objected very strongly, and her lawyers filed motions again, first saying that the Star Tribune didn't have standing to petition for access, and then the court found that the Star Tribune did have standing. There was a public right of access, and then they said that the parties relied on this being confidential, and there's no reason for anybody to look at this divorce file, and the public interest is not served by opening this file. And a couple of months ago, then President-elect Donald Trump, there was a petition to access his 1990 divorce records in New York State Court, and the New York State Court said, no, you don't get to see his records. The thing is, this is Minnesota. The presumption is in Minnesota that family court records are public, and so over the objection of the surviving ex-spouse, the records were made public, since despite the reliance of the parties despite their agreement, there was not, in fact, a legal basis to make their divorce records non-public. If you're wondering what court records specifically are non-public, you can look at Public Access Rule 4. The rule lists all non-public case records. There are always going to be some situations where the rules don't really work the way they're needed to in a particular case, and judges do have discretion to issue protective orders in individual cases to make otherwise confidential or otherwise public records non-public. However, to do that, the judge must make findings that are required by law, court rule, or case law precedent. Now, what those findings are is going to vary depending on what type of case you're in and also what type of document. For example, the United States Supreme Court has said there is a First Amendment right of access to criminal case records. They have not extended that yet so far to civil cases. However, the Minnesota Supreme Court has said under Minnesota law there is a common law right of access by the public to civil case proceedings. If any of you work in juvenile protection cases, there's a provision in the juvenile protection rules specifically addressing public access to juvenile protection cases. Again, those are generally public cases. And then in the juvenile delinquency rules for public juvenile delinquency cases, there is also a provision in the rules governing the standard for making them public or non-public. So if you do need to ask to have for a protective order making public records non-public, then you should look at research the law to determine what the standard is for the type of case you are filing in. Number 3 is the thing you need to know of the top 10 things is to separate non-public from public. I think sometimes people assume that court staff, they go through and screen for non-public information. That is not their responsibility as the filer. You control what you file. Court staff, in a paper world, it was quite easy for them to, if there was non-public information, they could separate the non-public pages, put them on the left side of the file, and then all the public stuff would go on the right side of the file. But in an electronic filing system, it's not practical for them to do that. And so the rules say that the person filing is responsible for separating non-public information from public information in court filings. And again, you should look at the Supreme Court's rules of public access if you have if you're wondering if a particular piece of information is public or non-public. The public access rules, they are posted on the Minnesota Judicial Branch website. There is also a table that State Court Administration puts together of listing all of the non-public case records, and so that's a reference if you're wondering if something is public or non-public. Again, one of the most important things are restricted identifiers. Those mean social security numbers, employer identification numbers, and financial account numbers. Yes, please. For the people on ITV, the question is credit reporting agencies, did I understand? Or
for example, when you get your credit card statement, they will have 1, 2, 3, dot, 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 4751.
Okay, so the question is if sometimes you'll have a document from a credit card statement or some company where they'll have a partial social security number, maybe it'll be separated by dashes. Under the court rules, that is still prohibited. No part, in state court, no part of any social security number can appear in a public court document. And the reason for that is those have been used, even a partial social security number, people have succeeded in using those to steal someone's identity. Now, a financial account number, you could do the last 4 digits, but with the social security number, you can't have any part of it in a public document. I think I saw a hand back there.
When you send it over to the attorney, they get the whole case number. So how would you handle that?
The question is if you're doing a check forgery or check fraud in a criminal case, you need to, as part of making your case, you need to file bank statements that would contain account numbers. There are two ways that you could handle that. The first would be to redact the account number. However, it may be, especially in a criminal case, the specific account number, maybe that's part of probable cause. In that case, you can use Form 11-2 to file your financial source documents. If you look at the state court website, there's Form 11-1, that's for restricted identifiers. Form 11-2 is, you can use that for financial source documents such as a bank statement, W-2 form, tax returns. And so what you can do is if you file it with a Form 11-2, then the financial source document stays non-public. The judge can see it, but the public can't. The public can just see that there's this non-public document that's been filed, and that way the public knows what the judge is looking at, but they don't get to see the actual document. And identity thieves also don't get to use court records to steal that person's identity. Where we typically see the confusion here, most people know to, in general, look out for social security numbers, be careful with them, not so much with financial account numbers, and so that's where we typically see violations of Rule 11. If you're wondering if a particular number is a financial account number, the last 2 pages of your packet are a Rule 11 financial account numbers cheat sheet. This is, again, court staff, they're not responsible for screening for financial account numbers or social security numbers, but if they do see a social security number, financial account number, then they're instructed to take action to lock down the document, make it non-public, initiate the striking process. And so if they're wondering, is a particular number a financial account number, then this is the list of numbers they're directed to look at. And so we have this posted on our public website as well so that people can see what court staff are directed to consider as financial account numbers. Another issue with separating non-public from public is terminology. The terms confidential and sealed, those are both legally defined terms in General Rule of Practice 11. They do not mean the same thing. And so what confidential means is the public doesn't get to see it, but court employees can see it. Often government agencies can see it through new MGA, but the public can't see it. Sealed, that means that not only the public can't see it, but also government agencies can't see it. Most court employees can't see it. Basically, judges and just a few court employees can see it. Yes, please.
Why did they get rid of the next stop?
Yeah. The question was, why was in EFS there was a drop-down box where you could just click public, confidential, or sealed, and then it was changed to you have to type in public, confidential, or sealed. I believe the reason for that was the thought was there's a lot of non-compliance with people designating non-public or public, and by typing public, confidential, or sealed, you actually have to think, is this public, confidential, or sealed? The thought was people were just clicking. I'm not saying everyone does it. It's just that some people may have just been clicking public or confidential. I have to click something, but since I have to click it, I don't have to type it. So the goal was to make people think about whether it really is confidential or sealed. So again, though, with the so you can see the screenshot in the middle of the screen. That's from EFS. It's the filing comments field, and you are required to type something in that field for every document you file. That's where you can designate something as public, confidential, or sealed. And by typing it confidential or sealed, that ensures court staff know that the document should be confidential or sealed. And again, unless you have a specific legal basis, generally one of the rules of public access authorizing your filing as confidential, then you do need to have an order from the judge making it confidential. Alternatively, the rules also allow you to simultaneously, if you could file the document and simultaneously file a motion for an order making it confidential. However, in general, you do need to have a specific rule authorizing the filing as confidential. And again, confidential and sealed, they mean two different things. Where this gets to be a problem sometimes is with proposed orders, making something confidential, and you'll see language such as, in the proposed order, these records are sensitive, contain sensitive personal information, and shall be confidential and sealed and inaccessible to the public. For court staff, that poses a problem because those mean different things. Should it be confidential or should it be sealed? Which should it be? And so if the intent of the order is simply to mean that the record shall be inaccessible to the public, then to simply say the record shall be inaccessible to the public, that's enough legal authorization if it is in a signed court order for court staff to keep the records from public view. The other part to separating non-public and public documents is that you need to file, if you have an attachment, may have a confidential attachment to a public document, when you e-file, you need to file those as two separate PDFs. Again, in a paper world, it was easy enough for court staff to just take out the confidential attachment, put it on the left side of the file, but it's very difficult for them to do that when you e-file, and so you should file them as two separate documents. Two common examples: medical reports under the public access rules, medical records are confidential. Custody evaluations, also under the access rules, are generally going to be confidential. Maybe the issue is someone's mental health or someone's physical health. Maybe it's a personal injury case and you have an affidavit describing the person's injuries. The affidavit itself is going to be public, but then you want to attach a doctor's report as an exhibit to the affidavit. That doctor's report is non-public, and so what you should do is file them as two separate PDFs. That way, court staff, and you can file them in the same virtual envelope in EFS when you do that. That way, court staff know that the documents belong together, but they can also separate them, and so that they make the affidavit public, the medical record non-public, and that preserves public access to the court record, and they also know to put them together in Minces so that it's clear that they belong together, but they do need to be two separate PDFs. Another point, and this is language that was added, Public Access Rule 4, Subdivision 4, added in 2015. In general, once a non-public document has been filed with the court, you are free to quote from it in public court filings. Maybe it's a psychiatrist's evaluation, a psychiatrist's report saying this person is diagnosed with schizophrenia, and all the details for the psychiatrist's reasons for making that diagnosis. That's going to be non-public, but then you could simultaneously quote from that in a motion or an affidavit saying Dr. Smith diagnosed Mr. Jones with schizophrenia, and pretty much all the details can go into public documents. And also, once you've filed a non-public document, not only can you quote from it, the other side can also quote from it. So that's the rule of thumb that I use is, if you wouldn't post it on Facebook, think carefully before filing it with the court, because even if it's in a confidential document, once it's been filed with the court, anybody can quote from it. So again, talking about what could go wrong, this is from a federal district court in Minnesota back in 2010. Some strong language from the judge, a little bit of background first. The attorney had filed, it was, I believe, a civil case. The attorney had filed a number of documents, and the judge or one of the court employees noticed that there were several people's social security numbers that were filed. And so there was a hearing. The judge brought this to the attorney's attention. The attorney said, "Oh, Your Honor, I'm very sorry. Those were clerical errors. I'll get those addressed immediately." The fact that the attorney chose to call this a clerical error made it into the judge's order, also suggesting the judge was not happy to see that the attorney thought this was just a clerical error. A couple of hours after the hearing, the attorney files another version of the documents and had drawn black rectangles over the social security numbers. The trouble is, with an electronic document, if you just draw a black rectangle over it or highlight it in black, that generally is not going to effectively redact. You need to use an actual electronic redaction tool. And so at that point, the judge had enough and decided to sanction the attorney. And let's see, the sanctions were the attorney had to notify within 10 days. This was right before Thanksgiving, so it was 10 days to allow for the holiday. But 10 days, notify everyone whose social security number had been disclosed in a court filing, offer all of these people 1 year of credit monitoring at the attorney's expense, pay $300 to a local food shelf, and then also appear for a status hearing right after the holiday to advise the judge on whether the order had in fact been complied with. The judge also said the days of attorneys being able to ignore the computer and shift blame to support staff in the event of an error are gone. The consequences are simply too serious. It is the responsibility of counsel to ensure that personal identifiers are properly redacted. some strong language from a federal district court judge. As I mentioned, state court judges also have sanctioned attorneys when they don't keep out non-public information from public documents. If you look at this case if you look up this case and look for other cases citing it, you'll see a similar thing happened down in St. Louis, Missouri in 2015, and the federal judge there took a slightly different route. Said, counsel, here's a copy of the eFiling rules, and I'm ordering you to take these rules back to every attorney, every support staff in your law firm, and they are all going to read the rules, and then you are going to file a written statement in the court file certifying that every attorney and support staff at your law firm has in fact read the eFiling rules. A little bit of a different tack, but again, that's another example of a judge who sanctioned an attorney for failure to keep non-public information out of public court filings. And again, aside from sanctions, putting unnecessary personal information in court filings could embarrass your clients. Where we see some issues with this regularly, custody cases, family law cases in general, the intensely personal, what most people would consider a very private dispute, but once you bring it into court, it becomes public. And so, social media, I think family law attorneys generally say social media is a gold mine for information in custody disputes. You'll get these, it's not uncommon in court filings to see screenshots from messages people have sent to each other back and forth, fighting over their children, or disputes over pictures of the children getting posted on Facebook. And once that gets filed in court, that is all public record, and it's anybody can read it. That means your client's neighbors can read it. That means the people down the street, grandparents can read it. It is all public once it gets filed in the court. Now, in a paper world, there is this concept of practical obscurity. What that means is most court records, even though they were public, they were effectively private because, let's say you were litigating up in Coochin County and someone else wanted to look at your court records, they'd have to drive up to International Falls to go to the Coochin County Courthouse to look at your court records. But now you don't have to go anywhere. I mean, right here in Wilmer, you can just go down to the first floor, the public access terminals. They are available. The Coochin County records, they're available right now. And with the Minnesota Judicial Branch, we are in the process of making documents remotely available as well. Not all court documents will be remotely available, but many of them will, just like they are with the federal courts with PACER. Soon they will be available in state courts also, and it's planned to be with documents filed on or after, I believe it's July 1st, 2015. So what you file today is probably going to be remotely available in the near future. In other parts of the other areas of society, people really expect on-demand access in an electronic world, and we are moving to doing that in the courts as well. So always keep that in mind when you file it in the courts. It's likely going to be available everywhere. At this point, you're probably wondering, what do the courts do to make sure that we ensure appropriate public access? What we do is we have a system of document security classifications. Every single document has an electronic designation. It's called a security classification, and so that dictates who is able to see the documents. Is it available remotely? Is it just available to the public at the courthouse? Can government agencies see it? Can only certain government agencies see it? Maybe only court staff can see it, or maybe only judges can see it. There are all these different security classifications. Your role as the filer with security classifications is to designate your documents as public, confidential, or sealed every time you file. And that helps court staff. Because by designating non-public documents as either confidential or sealed, then you flag them for court staff. That way court staff know to make sure that the documents should not be, either they should be public or they should not be public. The number 5 thing, and this is related to number 4, is to use precise filing codes. Show of hands, how many here have filed through EFS in the room? Just about everyone? Okay, good. I'm glad people. I'm going to be giving this presentation to a group of new lawyers in a couple of months, and it'll be interesting talking with them about a system most of them have never used, so I'm glad to be talking to people who have already used the system. In EFS, every single document you select a filing code. As you know, there are quite a lot of filing codes, and the reason for that is there are two sides to that. The first is there are some documents that are usually non-public, and so we have filing codes for almost every type of non-public document. And for the non-public documents, the filing codes, the system will flag them automatically as being confidential. So that is, by using the most precise filing code for your confidential documents, that gives you another layer of security to make sure the confidential documents never become public. And also, by using the most precise filing code, you make it easier for the judge and for everybody else to find your court records. I mean, I'm sure you've all seen those long registers of actions where it's just document other, document other, document other. It's difficult for everybody to find, which document other is it that we're talking about. It's also difficult for the judge, and so by using the most precise filing code, the example, you can make it easier for the judge to find your document. What I've got on the screen, affidavit of service by posting, and then also affidavit other. Let's say you have an affidavit of service. It would be more precise to select affidavit of service as opposed to affidavit other. It's not that affidavit other isn't accurate, but affidavit of service is the more precise one. Maybe they were served by posting on the premises. There's even affidavit of service by posting. And also with the filing codes list, you can click on it and you can search by word. So if you know it's an affidavit, if you just type in affidavit, you'll get, you can just type that in, and then all you will have to select from are the filing codes containing the word affidavit. The other side to using precise filing codes is the filing description field. Again, that is a mandatory field in EFS. You have to put something in it for everything that you file. Example I have up on the screen. Let's say you've got an affidavit of plaintiff, and the plaintiff's name is Jane Doe. You could type in affidavit of Jane Doe in the filing description, and then you can see in the lower right-hand corner, that's what it will look like on the Register of Actions. It'll say affidavit of Jane Doe. So if you've got multiple affidavits by different people, you could say affidavit of Jane Doe, affidavit of John Smith, and so on. Maybe you've got a public affidavit, but it's got one exhibit that's confidential. So you file the affidavit in the first exhibits, and then you could file that in the description, say affidavit of Jane Doe with exhibits A through I, and then you could file the separate confidential document as confidential exhibit J to affidavit of Jane Doe. That makes it easier for the judge to, and the other attorneys, but really what you care about is making it easy for the judge to find your court record, your filings. That makes it much easier by using that precise filing description for the judge to locate your filings. Maybe that you don't really have any information to put in the filing description field. It is, however, a mandatory field. If there's nothing particular that you need to put in there, we recommend typing an asterisk, typing a period. Please don't type something silly like Killer Ninja's rulers. We have seen people type random characters or some thinking I have to put something in there, so I'm just going to type this random stream of characters. It does become part of the court record, and we don't really need that sort of thing to get into the Register of Actions. So if you don't have anything to type in there, just an asterisk or a period, that'll suffice. The number 6 of the top 10 things you need to know are to make sure that you are paying correct filing fees. This ties back to number 5, using precise filing codes. The EFS system makes different fees available based on your selection of filing codes. Filing fees are set by the Minnesota legislature, and so there's one, as you know, there's one fee for your first paper filed, your complaint, your petition. It's a higher fee if you're in a dissolution petition. There's a motion fee. Generally not a fee for filing an affidavit, though. Court staff, there are very few reasons why Minnesota court employees are allowed to reject a filing. One of those reasons is if correct filing fees are not paid. Court staff are directed to reject filings if the fee isn't paid. And so make sure that you're paying the correct filing fee, and one of the ways that you can help ensure that you have the correct filing fee is by using the correct filing code. And some of you may have, if your client has a fee waiver, maybe your client's informa pauperis, the best practice is to, you can set up a fee waiver account in addition to your credit card, your debit card account in EFS. If you do have a fee waiver, it's better to use your fee waiver account as opposed to putting it on your credit card account and then charging $0.00 to your credit card, because That makes it clear to court staff that you are not refusing to pay fees. It's just that your client has a fee waiver, and so you're using your fee waiver account. The number 7 of the top 10 things you need to know is to allow time for processing. Yes, with e-filing, you can file until 11:59 p.m. Minnesota time, and you have filed it as of that day. However, almost staff do need time to process your filings. The process is largely automated, but most court filings are reviewed by human beings before they become part of the court record, and so staff, they do need, I mean, most of them work, I think it's 8 to 4:30, somewhat different hours, but I mean, they do need some time to process your filings. Also, being a human being, the judge will need some time to review your filings. They are not going to instantaneously have your filings. It's quicker than it was in the past, but it will not be instantaneous. One of the reasons we've had this, sometimes if people have tried to e-file something at 8:55 a.m. for a 9 a.m. hearing and then been surprised that the judge has not, read their pleading within the last 5 minutes, being the fact that it hasn't been processed yet. So you do need to allow some time for processing. If you're wondering if a particular document you have filed has been fully processed into MNCIS, a quick way you can check that if you go to the public pa.courts.state.mn.us, look at the Register of Actions for your case. Once your document has been processed into the system, it will show up on the Register of Actions. And so once if your document is listed on the Register of Actions, that means that it is available in MNCIS for the judge. Number 8 is to protect and perfect your appeal. Let's switch for a second away from the district courts. Let's go to the appellate courts. Show of hands, how many of you have practiced in the appellate courts? See, a couple of hands in the room. Minnesota's appellate courts, they use a separate e-filing system. It is called EMAX, and as with the district courts, e-filing is mandatory for all attorneys in the appellate courts. That went into effect July 1st of 2016. That was done by 2 Supreme Court orders. And sometimes people don't realize this, but EMAX is a completely separate system from EFS. EMAX is for the appellate courts. They are a separate system from the district courts, which uses EFS. And so by registering for EFS, that does not mean you have registered for EMAX. To register for EMAX, it is a separate registration process, and you do have to pass a quiz on the appellate procedural rules. Having taken the quiz, I can tell you, I believe it's 10 questions. It's not the easiest of quizzes, and so, I mean, it is an open book quiz, but you do have to get a certain number right. It is designed to test your knowledge of appellate procedure before you're allowed to e-file. So if you do have something that you need to file an appeal on by 5 o'clock today, make sure you allow yourself some time to register for EMAX. And again, I like to talk about what can go wrong. Remember, e-filing went mandatory in the appellate courts in 2016. However, over a year later, these are from, June 13th, 2017, attorney did not realize that that e-filing was mandatory at the appellate level, and so mailed in the appellate documents. The clerk of appellate courts sent them back saying you need to e-file, and then the attorney attempted to e-file, but by that point the attorney was past the deadline. The Court of Appeals said we don't have jurisdiction to hear your appeal because you did not perfect your appeal within the deadline, and so the appeal was dismissed for lack of jurisdiction. No petition for further review was filed in that case. Let's go to July 18th, though, of 2017. Another Court of Appeals decision, again dismissing an appeal because the attorney didn't realize that that e-filing was mandatory. And the attorney then, the way the process works is the Court of Appeals will send you a letter saying, or an order saying, we question if we have jurisdiction by this date, file a brief explaining whether or not you think we have jurisdiction. And so the attorney's response was, well, I didn't realize that I had to e-file, and yes, it says that e-filing is mandatory, but that doesn't mean I have to e-file. Not quite sure. The attorney was trying to, work the language of the rules a little bit to, support his. I believe this attorney was mailed to support his contention that he had perfected the appeal. Court of Appeals disagreed, dismissed the appeal. Then there was a petition for further review filed with the Minnesota Supreme Court. And that petition for further review was denied September 19th of this year. So again, those two cases over a year after e-filing went mandatory with the appellate courts, neither attorney knew that they had to e-file. Similar thing happened in August of 2017. This case actually has a happy ending. The attorney tried to file the appeal by mail. It was an interlocutory appeal. And the only reason that appeal was saved was because the district court had the court administrator had entered judgment about 5 days too early. And so the Court of Appeals looked at it and said, well, hold on, the district court entered judgment too early, and so we have to recalculate the appellate deadlines. And actually, we will find that this particular appeal was timely. But again, that was just a procedural irregularity on the part of the district court administrator. It was nothing that the attorney could have done other than just sheer luck that appeal was saved. So one of the themes here from the last one is just to stay on top of the rules. So the number 9 thing of the top 10 things is to stay current on filing requirements. In 2015, the state courts switched to doing what the federal courts do, and that is to put the electronic formatting requirements in the Minnesota District Court Registered User Guide for electronic filing. I've got it printed off here. It is posted on the Minnesota State Court website. So that's got things like you have to use 8.5 by 11 inch page size. You have to do portrait orientation, not landscape orientation. You can go up to 25 megabytes per document, 35 megabytes per envelope. So if you have questions about formatting requirements and also just information about using the e-filing system in general, some of the common issues, those are set out in the Registered User Guide. Also, if you're wondering about how to use the e-filing system, or if you've got new staff who want to know how to use it, if you go to mncourts.gov/e-file, you can find information and training materials about, how to log on to EFS, how to register for an account, that kind of thing. For Emacs, again, that is a separate system. It works differently from EFS. If you go to emacs.courts.state.mn.us, click on e-filing FAQs and e-filing help. They've got, again, detailed documentation about how to use Emacs. Now, the number 10 of the top 10 things is to create your pleadings electronically. We are an electronic court system, and so you should be creating your pleadings electronically. One of the formatting requirements is that filers should not print documents on paper and scan them before filing them. A couple of reasons. The first is it's best if documents are text searchable, especially longer ones. With a scanned document, the only way that you can make a text searchable is to add optical character recognition data. The thing is, optical character recognition data has been shown to cause the documents to be rejected by the system. There can be a technical failure. If that does happen, that means that you've lost your filing date. And so you should be printing on paper and scanning only when it's not possible to convert an electronic document directly to PDF format. Maybe, for example, there's a dispute over a contract and the contract was signed on paper and you need to introduce the contract into evidence, then that would be a situation where you do have to scan the document to an electronic format and then file it. So it's not that scanning is prohibited, it's just don't do it unless you have to. Other issues with scanned documents, they do have much larger file sizes. I mentioned the 25 megabyte per document limit. I will tell you, if you don't scan your documents, you will try very hard to hit 25 megabytes. One of the things I do is labor relations. We had a dispute with the labor union the other year, and I sent them, I think it was 1,400 pages of documentation, and it was all prepared electronically. It was 4 megabytes. But again, if you are scanning on paper, it is pretty easy to hit 25 megabytes or go above that with a scanned document. Also, in general, if you scan your document, it's going to be harder for the judge to read, especially if a lot of the judges, they'll use tablets, iPads, Surface Pros to look at court records. It's harder for the judge if it's scanned. And also, you always like it when you have that very well-written motion or memorandum or brief or whatever, and then the judge copies some language directly from it, pastes it into an order. It's a lot harder for judges to do that if you scan your documents. So for all those reasons, it's best to prepare your documents electronically. One of the questions we get is, well, what about, don't I have to sign my documents and don't I have to sign by hand? In general, it is not necessary to sign by hand. General Rule of Practice 1404 lists the different types of signatures. What's called a typographical signature in state court rules, you can just type /s/ type your name, and then that is legally a valid signature under state court rules. It's similar to what they do in federal court. And again, you can sign by hand. Maybe you've got a marital termination agreement. You've worked very hard to get these two parties to finally agree on everything. You just want to have, both parties and both attorneys sign it, get it filed, get it entered, get it all done as quickly as possible. It's permissible to sign by hand, but it is not necessary to sign by hand. It is also not necessary to notarize, and there are very limited exceptions where you have to notarize. The two that I can think of are admissions and consents to adoption in adoption cases. The only reason for that is those are people giving up their parental rights, and so we should have the notary make sure that this is, in fact, the person giving up their parental rights. But in general, it is not necessary to notarize. Again, this is the same as the way they do it in federal courts. We have a state statute, 358-116, that says if the court, if you sign under penalty of perjury without a notary, and you file it in Minnesota state courts, and you knowingly make a materially false statement of fact, then just as you would be if you did that in front of a notary, you are guilty of perjury. You are looking at a felony conviction and up to 5 years in prison. So it is not, in fact, necessary to notarize. Again, you can notarize. It's not prohibited, but it's also, in general, not necessary. Another change for creating your pleadings electronically is consecutive pagination. I think many of us have done this in the past where it's just like I have little numbers on the slides to help me follow along, and also if you look at your handout, you also have consecutive pagination. But consecutive pagination, General Rule of Practice 16, it was enacted in 2015, and what it says is to the extent you should have consecutive page numbers on everything you file. By having those, it's a lot easier for the judge and everyone else. You can cite to the specific page using the document ID number, and makes it easier, again, for the judge to find the information that you want the judge to find. And if you are turning the page as I just did, you will see we have a surprise number 11 bonus on top of the top 10 things you need to know, and that is signing up for eService. And yes, in EFS, you are still required to choose each case on which you want to be a service contact. Registering for an EFS account is not the same as adding yourself as a service contact in the case. And again, you are prohibited from signing up other parties as service contacts. Why is this the case? A couple of things. Some of it's a technical limitation, and also from a policy matter, when you agree to be e-served, which you have to do if you're an attorney, then you're agreeing to monitor your email address and timely respond. And so we want to make sure that that is the email address at which you have agreed to be served. So it's not like you can choose the other side's out-of-date email address or maybe have a typo in their email address. So you do have to add yourself as a service contact in each case. That by doing that, that ensures that it is the email address at which you are agreeing to be served. In contrast, in Emacs, remember I said Emacs, different system, works differently, different court system. By registering for an Emacs account, you are agreeing to be served in future cases. And so in Emacs, you don't need to add yourself as a service contact. The clerk of appellate courts will add you as a service contact if you have already been registered for an Emacs account. And again, with the appellate courts, they have a much smaller volume of cases. They are able to add attorneys as service contacts in cases. But remember, with Emacs, make sure that your Emacs account, your service information is always up to date. Where this sometimes has been a problem is if you have an attorney moving from one law firm to another law firm, the email address changes. Make sure that you update the email address in your Emacs account before you transition, or contact the clerk of appellate courts to make sure that's updated, to make sure that you have a current email address in your service contacts for Emacs. If you've got questions, I'm happy to stick around, both for people here in Wilmer and also for people over ITV. Also, if you have technical issues, please contact the EFS Support Center. The EFS Support Center, they handle both EFS issues and also Emacs issues. And the nice thing about contacting them, not only are they well experienced, very experienced with handling technical issues, they also keep track of them. And so if there are repeated technical issues with EFS, we're aware of them if you contact the EFS Support Center. There are written resources for e-filing in the district courts under mncourts.gov/efile, including the registered user guide, which has the mandatory formatting requirements and the financial account numbers cheat sheet. And then also for the appellate courts, you can go to emacs.courts.state.mn.us. And also you can look at the appendix filed that I've provided at this CLE. I've got the legal citations and also the text of the rules that I have cited to. And at this point, that's all I have. If any of you have any questions, I'd be happy to answer them.